actually trademark scent or sound.
Netflix. You know how Netflix every time you
Tudum.
start, tudum, yes, tudum.
Your business, your logo, brand. Ed Sheeran previously.
Yes.
He was sued for the song Shape of You. Hi, welcome back to Law Unfiltered again. Today I'm doing my next episode with my good friend here, Wei Yang from
Hi.
Sean Chan and Co.
Oh, yes. Nice to meet you.
Thank you for being here.
It is my pleasure.
My pleasure.
Very honored.
I'm honored too.
Huge fan.
Thanks. Okay, so today we're going to talk about a topic, a mistake. In fact, a lot of people make when they start building a business. Like for example, when you spend so much time building your business, your logo, brand, your business identity or formula, if I may, you know, and some people, well, what if you're already successful and then some people come in and whoop, copy your idea. Then you lose everything. Everything is gone because somebody will be copying your logo, your brand. People may think that, oh, actually this brand belongs to this person instead of you. So now, how can you protect your business identity before you even kickstart that business itself? So this is what we're going to talk about today.
Yes.
Now, there are so many ways for you to actually protect your business identity or brand logo or whatever. For example, with trademark,
Yes.
right? Trademark now, there's a lot of very popular trademark that we all know, like for example, Nike.
Yes.
What else?
McDonald's.
Or, you know, Apple, you know, the bitten Apple logo.
Yes.
That is also the trademark. What else?
Starbucks. Yeah.
Harley Davidson.
Yes.
All this is trademark. Now, as long as your logo or your brand is capable of being represented in graphic terms, then you can apply for trademark application, right?
Correct. I would say it actually depends on context and case scenario. Let's say in any event, if your mark you build out such a good reputation, the name is so renowned, you can just immediately register it as a word mark. For example, let's say Starbucks, for example. Let's say Starbucks hasn't registered their trademark. They operate for let's say 20 years. Everyone and their mother know what Starbucks is. So they proceed to register it. I don't think anyone will oppose the mark Starbucks because everyone knows what is Starbucks.
What's Starbucks? Yeah,
yes,
exactly.
So it would it's basically automatically a free win basically. You just register it and bam, you got it. A trademark Starbucks.
True, that's true. Yeah, actually I've done before a trademark, right, where they did not allow the trademark logo because they say it's not distinctive enough because it was like a alphabetical like for example P and N, and then you just P and N and then the logo itself. So they were saying look, this is alphabet.
Yes.
It's not distinctive enough for you to apply for a trademark itself. So it has something to be careful with when you are creating a logo. Not make it not so generic, I would say.
Yeah, because I think once you register a trademark, right, it means that other people cannot copy your mark. You know, let's say if you just want to register the word P and N, like what you gave an example. In the future, anyone who wants to register the mark P and N, they cannot use it anymore. You know,
Yeah,
you cannot monopolize generic words like P and N. That's why, in most cases that I encounter, people tend to mix marks. You know, half shape, half word. That's quite a mixed mark to try to get it registered. But even then, I would say to establish distinctiveness, you need, substantial goodwill and reputation. Your name has to be good enough. It has to be unique enough to be capable of being registered.
Yeah. And then, I recently read that for the purpose of this podcast, obviously, I went and read and I saw that Taylor Swift actually wanted to trademark the life of a showgirl, that brand itself.
Yes.
But apparently was unsuccessful because there was another thing called Confessions of a Showgirl. So now this is so they are both the same, it is for entertainment purposes, also like musical and all that. Then it's not distinctive. People will be confused. So confession, is it the same with the life as a showgirl?
Actually, I would say it is, because I think because they are registering under the same class, the entertainment industry. Because for trademarks, right, it depends on what class you are registering. Let's
What
say
kind of class do we have?
every single class, actually, there's like cooking class, like bathing class, showering class. Every class also available for trademark applications. It just depends on what class you're registering. Interestingly, you can register for multiple classes at once also, and see which classes go through.
Yeah.
So for Taylor Swift's case, I think it shows that like no matter how famous you are, right, if you're
But we all know, right?
Yeah.
Life of a Showgirl is Taylor Swift's song.
Yeah, even if she's so famous, like even I think everyone know her here, you still won't be able to get through, even if you try to apply for it. Just because there's already another mark there.
Yeah, that's true.
Yep.
I mean, I think she's still going to appeal with it. I'm just not sure, like, is it going to be successful?
From what I last heard is like apparently it's frozen, so I think she's seeking her legal advice to see whether we want to proceed or not. But if I were them, I wouldn't know lah, because the word of a showgirl is behind. It's quite substantial lah. No, it's similar to the other one, Confession of a Showgirl and Life of a Showgirl.
It's
very hard.
Life and Confession is basically the different thing.
So how to see whether the marks are similar, right? You have to see the substantial part of the mark. So I think the substantial part is the word showgirl here. That's why they are preventing Taylor Swift from registering, even though she's Taylor Swift. Yep.
That's true.
Yes.
So now, interestingly, just one question. Okay.
Yes.
Can you actually trademark scent or sound?
The answer, if it is overseas, I would say yes. But in Malaysia, the answer is maybe. So because you know why? Because you have to. If you're trademarking something, right, means you own the right to something. So how are you going to own the right to a smell or a sound? But in very rare cases, right, the court actually allows such registration. A good example is Netflix. You know how Netflix, every time you start, that is registered as a sound mark in US, if I'm not mistaken. So how Netflix did it, right, they submitted the graph that shows the sound wave, and they say it's so unique, that it entitles it to be registered. But I must put a caveat here, like in the event Netflix want to, monopolize such a mark, right? I think it will have to be so similar to the sound, then only it can be infringed. I think, for example, you make a sound like, then this won't be infringing. Yes.
Okay, then scent. I'm pretty sure Jo Malone's scent is not trademark lah.
I don't think any of the marks are trademarked in Malaysia.
But Jo Malone's scent is very distinct, no?
I think they have tried before, but if I'm not mistaken, it's still pending registration results. Because as far as I'm aware, Malaysia trademarks for scent and sound marks are, left in limbo. I don't think any scent or sound marks, correct me if I'm wrong, I really am not too sure about this, have not been registered yet.
I see. Because, I mean, again, for the purpose of this podcast, I also did some reading on like scent trademark, and it's not allowed actually, even though if you give like the chemical the equation, right, how you come up with this scent.
Yes.
Or like that, like you give like a description of how the smell is together with the chemical formula. Even that itself, the court did not allow. It says it's not distinctive enough for you to actually trademark it.
Yeah, because I think it's different from like, let's say a logo. If you want to monopolize a logo, it's possible. You can, you can distinguish it quite easily. But for smell, I think it's quite hard to distinguish smell. Like, how do you even see smell? That's a good question.
You can't.
Like, how you distinguish like normal word marks, you look at it a side-by-side comparison. Yeah. But for smell marks, how do you distinguish it? Like, someone must smell flowers, the other person must smell something else, you know what I mean? Like, how do you actually do it?
That's true, it's quite hard.
Yes.
So, another way for you to protect your business ideas or work is by way of copyright.
Yes.
So copyright is anything like film, music, lyrics. These are all copyrighted products. So if you infringe that, obviously it's wrong lah. But there is one very good example. Ed Sheeran previously.
Yes.
He was sued for the song Shape of You. One of the part of the lyric, when it goes like,
love with the shape of you. Okay,
okay, go. And so that part, right, they say it's the same with another song.
Yes.
And then after that fella came in, and I'm so sorry, I don't know what's his name, but what's the name of the song that apparently is so similar to
something
Shape of
old
You.
One, that's what I remember.
But it's like very similar to the part of So then it came. But then after that, the court, said that, look, there's no copyright because even the way that it was sang is different.
I think because, copyright infringement, right? Again, it's the same as trademark actually. Actually, most of these IP rights, right, their test is the same. Like, whether you infringe a substantial part of it. So the shape of you, it's not just the ooh-ah, ooh-ah, ooh-ah part, It has a whole lyrics about it. And this guy is trying to say
how the notes of the music goes as well,
yes,
right?
he's trying to say that this amounts to infringement, but
Yeah.
copyright infringement is not about that. You have to determine whether it infringes the substantial part of the work. In this case, it isn't. I don't see a possibility of it lah. That's why I think Ed Sheeran also, he went all the way, if I'm not mistaken.
Yeah, he went all the way.
And then he succeeded in defending his case lah.
Yeah,
I think
correct.
also it was a landmark case lah because, previously songwriters were,
It's simply getting sued for like copyrights because it's like almost the same or like almost the same note.
Yeah.
But I think after that, Ed Sheeran made a comment and like, look, it's really difficult right nowadays because like, pop songs, they only have like particularly these few notes to play around. So, of course, sometimes it may sound almost the same, but it is not the same.
Correct. That's why I think it really is a case by case basis lah.
Yeah.
But don't simply go and, say someone infringe your copyright lah, unless you're so sure, okay?
Yeah, unless it really sounds so similar.
Yes.
Right? Okay, so, next, patent. Patent, if you have new inventions, digital software, if you are working in any like food industry, chemical formulas or whatsoever, that one also under patent.
Yeah, I think patent is more like for invention, like technological advance. I had one case where that fellow had a patent when it comes to how the garbage are disposed of. He created a machine that allows less carbon dioxide to be come out of the air when the machine works. So he patented that, and subsequently someone infringed it, copied the same design and the same function. So in that case, I was acting for the infringer lah. So when I saw the thing, I looked at it, I told the fellow, you settle on the spot because when it's so clear, when you infringe the main use of it, you must settle.
There's no reason to fight for it.
Yeah, because the court will usually look at what is the invention. So that's what makes patent different. Like, how does this machine function, for example? Like, this machine functions to save the planet less carbon dioxide in the air. Similarly, my client's machine was the same thing.
Same function, same
function. Even though the design might be slightly different, but the function is the same. So I look at it, I was like, yep, there's no way. Let's settle.
I see.
Yes.
Now talking about the shape of the product, right? So there's also another way you can protect your business or your inventions is by way of industrial design.
Yes.
This one is to protect the shape of the object. I mean, like more commonly for the use of this.
Yes, this is this is purely just the shape of the thing. Like an example would be the Apple AirPods.
Yeah.
Those are industrial design. And
yeah.
then I know for a fact because you know why they also sued my client.
Really?
Yes.
But I thought that Apple sued Samsung.
Oh, they sued many people. They sued even my clients also. That one's for the AirPods. Samsung one is for the phone. The phone.
They said, okay, so what Apple did is they had a registration on the shape of this phone, right? You know, rectangular with the grid, got the grid, colorful icon, all that.
Yes.
Apparently got one time Samsung copied.
Yes.
And then obviously Apple was like, sue them.
Yes. And apparently it was called like, I forgot what it's called. They called it something Wartelli, something basically the biggest battle of the century or something like that.
Oh, I think so.
And in the end, from what I heard, the outcome
Apple
is,
won.
Yes, Apple won.
Some more damages. I think the damages they calculated by way, because this was in US, right?
Yes.
So because it's different, jurisdiction. So how the US court calculated is that however much, revenues you earn from that particular Samsung product copied with the Apple one, all the revenues are damages to be returned back to Apple.
Yes, a lot of money.
I think, it's a lot.
A lot.
1 billion if I'm not wrong.
Should be more actually, given that it's Apple lah. Come on.
Correct.
Everything is Apple. Apple Watch, Apple phone, Apple Watch.
Yeah.
Yep.
Okay, so now we know the ways we can protect our business, our brand, our product. Now, how do you register these applications? in my iPhone?
I'll start with trademark, okay?
Okay.
So trademark.
Okay, what are the documents you need? I know, but I cannot remember now.
In short, actually, you just need a statutory declaration to say that, yes, I'm the owner, this is the one I'm intending the logo, and that's it, blah, blah, blah. They also need the logo itself, a copy.
You need a lot of money.
A lot of, a lot of money, depending
Because you
on...
want to expedite it.
Yes, depending on... Okay, actually, normal way, depending on what class, 950 for those normal classes that are registered. For more special one, 1001 for each class. And then other than that, I think just normal documents.
How about we start with how long the application is gonna take?
This will depend on my poll, I would say. It really is a case by case basis. But if you want to expedite it, you can. I'm not
6 months, right?
It might go longer actually. If depends on what class you register. Quite literally, yeah. I got one case, the class was delayed for 2-3 years. Yeah, and then we caught the officer and yeah, apparently they're having issues.
What issue?
Technical issues.
Oh my god,
Yeah,
for
so,
2 years?
Yeah, it was in their backlog apparently.
Oh no.
Yeah. That's why I think MyPo was also, doing reforms sort of stuff.
So for your information, if you want to do trademark application or any application at all with My iPo, you do need a trademark agent,
Yes.
which is ta-da!
Yes, you can actually technically do it on your own, but I would advise against it. It's pretty dangerous because trademark agents usually do a background check. So we check properly whether there are any similar marks and everything. If you simply go and register a mark and then you find out that you cannot do so, you just waste your money. I mean.
Yeah, that's true.
Yep.
So anyways, documents, statutory declaration.
Yes. Usually it's statutory declaration, the logo, and then
Yeah, the logo
I think
itself. Coloured and non-coloured, right?
yes, and then a description, a general description of the
Yeah,
logo.
general description of the logo.
Especially if you're doing a mixed mark, you have to describe it. What's it about? Yeah.
Well, if I go on further with how to apply for this application, it's going to be very boring for everyone who's watching.
Yes.
So let's go on to what if your trademark has been infringed by somebody.
Yeah, you can do quite a lot of cool things actually. This is the fun part, okay? The registering is the boring part.
You're right.
The fun part is actually once you find out someone infringed. So, one very cool thing we can do is actually called a raid. A law enforcement raid. We can engage KPDN to go and do a lawful raid. Go and raid their premise and seize all the counterfeit goods. And then they will actually create a full inventory and list down what goods are infringed.
Yeah.
And then
you mean what goods copied that
what
logo
goods-
or the slogan,
Correct.
right?
Like for example, I would say for copyright would be very interesting. It's copyright because softwares are infringed quite frequently. People use a good example is Microsoft Word. Okay, most people use the pirated version of Microsoft Word. Okay,
Not me.
yeah. Okay, so how Microsoft do their cases, right? They target the big fishes, like companies, big companies who infringe the products as a whole. So they engage KPDN, they go raid their premise, they seize all the computers, they find which computers got all the, counterfeit products, and then they list down what versions, everything, very clearly for you. And then subsequently they escalate it further. Yep.
Okay. Now, but I also know that you can file for injunction, right? You want to stop these fellas from
Yes.
destroying the evidence.
Yes.
Let's just say if I copy Zeus lah, okay?
Yes.
Zeus logo. I put it on books lah, on the marks lah. These are all infringement of trademark.
Yes.
And then I know already, Zeus found out about it. Holy shit. I need to destroy evidence so that they got nothing to hold against me.
Yes.
Then I will destroy all of this evidence. Then when they come and raid me, then cannot find this evidence anymore.
Yes.
So what Zeus would do is to file for an injunction to freeze everything. I cannot touch anything. And for them to come and do the proper application and then to do the raid in accordingly lah.
Correct. So usually they will file a very urgent, ex parte, very, very urgent.
Tell the court, please give it to me.
Like literally you file one day, the next day is a hearing.
You'll get it already,
Yeah, you
yeah,
get it.
yeah.
You file an ex parte. If you really have proof that they are about to destroy it, then you just file it immediately. You get it, you immediately seize everything next day.
Correct.
But a lot of work, yeah.
Or if let's just say if after the injunction has happened and then you got the raid and then you found so many of these.
Yes.
So one of the damages you can get is again, it's the same as if like the Apple case as well lah. If there is any revenue that I have earned because I copied this Zeus logo, then all of the proceeds will go back to Zeus together with extra damages, of course.
Correct. You can actually elect what type of profits you want. It's either account of profits or just damages you suffered. Yep.
See what you want. Now, if copyright is infringed, it's not only civil remedies. You can also go by way of criminal sanction.
Yes, that's right. So usually after the raid, you find out the fellow's infringed already. You will send the fellow to criminal court and escalate further for the DPP to do it.
Yes.
So once you get the fellow's criminal conviction, you attack him in civil.
Well, but it's like, it depends because there is so many ways you can copyright a person's product, right? So like depending on what way you have infringed their rights, then you have like different sort of fines and imprisonment.
Yes,
it escalates further. Like maybe it can be less than 20,000, then 50,000, or imprisonment.
Yes. So what I'm aware is for software cases, it's 2,000 per licensed software infringe. 2,000 ringgit
per software.
per.
So that means if I have 20 computers, means 20 times 2,000.
Yep, that's right.
Plus the imprisonment.
Imprisonment usually for this kind of cases is very
or
unlikely.
It's either fine or imprisonment.
There's still the option there, but it's usually very unlikely.
Depends on the court.
Yeah,
if we say fine and imprisonment, then it's both.
Then different case are both, yeah.
If it's fine or imprisonment, then it's either one.
Yes.
See the judge.
Yes.
Whether she feeling benevolent for the day.
Yeah. See her mood lor.
See her mood lor. Yeah lor. Okay, so also there's one thing that I wanted to talk about just now, which is the copyright voluntary notification.
Yes.
So what is that about actually?
So actually, when it comes to copyright, right, you don't need to register your copyright, You're actually automatically entitled to copyright protection already. If your work is really capable of being copyrighted. You don't need to do anything, but there's this thing called copyright voluntary notification. So you just want to, it's actually the same procedure as going through registering a trademark, which is a hassle, okay? More or less the same one. But once you get it done, you can actually, it serves as what prima facie, upfront
that
evidence that you own this copyright. So that's what most people do. But there's another option actually. It's called a statutory declaration. You affirm a statutory declaration under Section 42 of the Copyright Act. That is also prima facie proof that you own the copyright. Unless they are able to rebut it. Otherwise. Yep.
See, there is actually so many ways for you to protect your business. I mean, if you have plans to expand your business to somewhere, to much more bigger things, then I really encourage people to do the trademark application. It's a one-off thing. You only pay for once.
Yes.
Unless, it's, rejected and then you want to appeal, then you have to go for a hearing, then you need to get a lawyer and then to attend the hearing.
Yes, you have to go to court.
You need to go to court. But again, it's a one-off thing because you only can apply for trademark once, right?
Yes.
So just get it done. And then, nobody can infringe it later.
Yeah, I think like if you don't register your mark, it's very difficult to actually defend your right, I would say. I mean, there is the option, but it is very difficult.
True. Because, the other time when I did this, trademark, the one I told you about, because it's like alphabetical.
Yes.
But it's a logo. It's like that. Then we kind of made some changes to it and then they kind of still rejected it. And then after that we appealed. We said, look, this is like so different compared to this other fella. And then because there is this word that is also similar to another, brand logo as well. Again, we went for the hearing and we said, we really distinctively point out what is the differences between these two logo. So, there's not much of an issue anymore. Then after that, the court agreed. So sometimes I think it's like sometimes application is not good enough. You have to go before the judge to convince them.
In the end, if you go MyPo, the officer will be one reviewing it.
But
if you go to court, then it will be the judge reviewing it.
Yes.
Sometimes MyPo might be mistaken, you know what I mean?
I think that's all.
I think we're missing passing off.
Sorry?
Passing off?
Passing off?
Yep.
Oh, come, let's talk about that.
Yes, passing off. The last one. So if your trademark is not registered, you can opt for this thing called passing off. So actually what is passing off? It's very interesting because passing off is actually the same, more or less the same as trademark, but instead of your mark being protected, it's your reputation, your goodwill, your name is the one that is being protected. So you actually don't need to register this passing off thing. It's a common law right. So a very good example would be, I just gonna give McDonald's. If McDonald's is not registered as a trademark, it still has substantial reputation that is capable of being
So many years
protected.
already.
So how trademark owners usually do, if their mark is registered, they go for dual action. One is trademark, one is for passing off, for more damages to be able to obtain. But I must say, passing off is very hard to establish.
Yeah, because you have to have
Yes.
such a reputable
Yes.
identity.
So you have to prove reputation. So how exactly do you prove reputation? You know what I mean? If you're not one of those big fishes like McDonald's, for example, how do you prove it? So what we usually do is we do a market survey. We actually basically go around and ask people, hey, do you know this mark? Do you know this mark? Do you know this mark? And you have to do it the whole of Malaysia, by the way. It's not just one area like PJ.
But
The
how are you
whole of
going to do
Malaysia.
that?
That's why you have to, there are people who do it, but it's very, very expensive.
Yeah.
Courts rely heavily on market survey to establish reputation unless you're so famous.
What if I can prove 90% of Malaysians know this brand? Is it good enough?
Then it's good enough. If you're so super famous, like let's say for example Ding Tai Fung, like everyone knows what Ding Tai Fung is, right? If you're so famous, you don't need to prove much. But if let's say you're a relatively unknown mark, like for example, I don't know, like my one, Sean Chan and Co. If you're unknown mark, you go around ask people, what is Sean Chan and Co? It's a bit hard, right? So I have to go get a proper market survey and go advertise it around and go ask around, hey, do you know what Sean Chan and Co is? You know what I mean?
Who?
Yeah, they will ask like, who? That's exactly. That's why you have to. That's why I'm saying it's a very hard thing. It's not like trademark, Trademark, once you register the mark, you can show the paper that, hey, look, my mark is registered. Like, even though the fellow can reply you, who? It's still registered. You can have it.
Yeah, it's still registered.
Yeah,
Yeah.
that's why it's much better to have your trademark registered.
God.
I think that's
Yeah.
about generally for IP rights.
That's
Most
about
of
it, right? Yeah.
Most of it.
So, I think we've come to an end to this episode. Now, I think what we cover here is pretty basic. We just want to give the idea of what kind of applications you can make to protect your business identity. That is the goal of the topic for today. And potentially, what can you do if somebody does infringe your IP rights, which is intellectual property rights. So, if you have any questions or if you have any IP related matters, you can feel free to give us a call.
You can put in an inquiry.
Yeah, I mean, my colleague recently got the trademark agent done.
I know.
The exam. So basically, that's that.
Yep. What's that? That's
So I hope this episode helps to give like a brief idea, and we'll see you on the next episode. Bye bye.
Bye bye. Thank you.